Thank you so much. Thank you, everybody, for joining me today. I am, delighted to bring you the latest information and hopefully answer some of the questions you have. I will leave time at the end for questions and answers. We're going to be using the Q&A feature. I think I've anticipated a lot of the sort of uncertainty and questions that you have. So it will probably be easier for me to hone in on the pressing concerns that I haven't addressed. If you wait a ways into the session before you start, populating that with your questions, because that way we'll get, through the most stuff. So let's talk about what's going on with public service loan forgiveness, income-driven repayment, and the expected changes in Washington and what that might mean for us as student loan borrowers, as people who are working in public service positions. And I will say, there is unfortunately a lot of uncertainty right now. So I want to be clear that, I'm going to give you my best um, informed ideas about what might happen. And that's really, kind of all that anyone can do right now. I also want to just say, there are many organizations that may have invited you here today. I want to thank the organizers and also just say, I speak for myself and not for, anyone or any other entity during this context. And just kind of giving that disclaimer helps me feel more free to sort of say what I really think. And then, you can take it or leave it, right? So, okay, so public service loan forgiveness is part of the Higher Education Act. It was created by Congress and it has been in effect since October 1st, 2007. So it is not the case that an administration or president or Department of Education can just by stroke of a pen eliminate public service loan forgiveness. It would take an act of Congress in order to remove the program altogether. Um, and so, that's important to know. And we'll talk some about, kind of what I think might happen potentially legislatively that could have an impact on public service loan forgiveness. But to begin with, let's, start from the understanding that it is statutory in nature, which makes it a little bit, which really puts it squarely in the purview of Congress in terms of making any real huge changes to the existence of the very concept of public service loan forgiveness. Now, of course, that's not the end of the story. There are also regulations that control the program and provide a lot of the detail that matters to us and to people who may benefit from it. There is a relatively new set of regulations that took effect July 1st, 2023, that were established after the traditional negotiated rulemaking process. However, regulations are promulgated by agencies. And so a new Department of Education may well at some point decide to revisit the public service loan forgiveness regulations and or to rewrite them. They are supposed to have to engage in a negotiated rulemaking process in order to effect changes to these regulations. And that process isn't fast. So I would expect that it would be some period of time before anything could really make a huge change to the regulations as they currently exist. But as we have our conversation today, I'm going to point out to you things that are regulatory in nature, and with the recognition that those regulations can be amended and may be changed at some point in the future, both within the Trump administration term as well as in future terms of control. So that's, kind of worth knowing. And then let's start with some of the kind of broad things to know about PSLF. I'm guessing that some of the folks joining me today have, are relatively recent graduates who are not immersed in this system or haven't been for as long as some of you may have been, or certainly as I have been. So I want to make sure we're all kind of on the same page about what the broad strokes of the program are. And then we can talk about a lot of, sort of crazy detail and current events that are, super relevant. The gist of public service loan forgiveness is that you have to, borrow student loans through the federal direct loan program, which is the federal student loans we all get, and really have been virtually the only kind of federal loans issued since the summer of 2010. So if you're someone who has very old loans, you may have some more complexity in your circumstance, but for the most part, the federal loans that you got for undergraduate and graduate school are going to be direct loans. Now, they may be direct unsubsidized, direct subsidized, they may be direct plus loans, they may be direct consolidation loans, but all those kinds of federal loans are eligible for public service loan forgiveness. You don't have to consolidate your loans in order for them to be eligible for public service loan forgiveness, unless you have very old or sort of weird niche kind of federal loans. You also aren't going to get any PSLF for private loans. So to the extent that you borrowed loans from banks or private lenders, those aren't eligible for public service loan forgiveness, and there's nothing you can do to make them eligible. So be cautious about considering refinancing federal loans into the private sector, because that may cause you to miss out on lots of federal consumer protections and flexible repayment plans and forgiveness provisions. Okay, so public service loan forgiveness is earned by you doing two things: working full-time for a qualifying public service employer while you are also making payments on your eligible federal direct student loans. Certain kinds of payments. And we're going to talk a lot about that payment piece because it's where, the kind of rubber hits the road, and there's a lot of wackiness regarding this litigation and other things that are impacting that. The employment part is a lot more straightforward. If you work for a government entity, whether it's state, local, federal, tribal government, that counts as a qualifying employer. Similarly, if you work for a nonprofit that is structured under 501c3 of the Internal Revenue Code, so that's legal aid organizations almost without exception, those count. Now, there are a few other nonprofits that are not C3s that can also count, but it's very, very narrow, especially narrow, and it's difficult to even think of examples of nonprofits that aren't C3s that do qualify, but it's not impossible. And there is no provision for for-profit employment of any kind to qualify towards PSLF. Except in a newly narrow case of independent contractors. If you're doing work for a qualifying employer like a nonprofit as an independent contractor, you might, under a narrow new sort of provision, be able to get credit for that work. You are not going to get credit for any work you do for profit or for labor unions, partisan political organizations, or if you yourself are an elected member of the US Congress. And you either have to be like directly employed getting a W-2 from the entity, or in this new regulatory environment, you may also be able to get credit for hours spent if you're in a position or providing services that under applicable state law cannot be filled or provided by direct employees. I'd like to sort of put out to those of you who may be interested in more conversation around this independent contractor bit to contact me offline and or Cal ATJ to sort of initiate some of those other conversations. I have a lot to say about that, and I think that we have a lot that we should be doing to think this through for people in a lot of different states. So, but that is beyond the scope of what we're trying to accomplish today. So I want to sort of throw that out there as like, yeah, this matters, and you should have questions about that, and we should talk. But also that we're not going to do that right now. So, okay, so public service loan forgiveness is about working in public service and making payments. Okay, so the employment part is a little bit easier. You have to work I'm not saying it's easier, it's more straightforward to understand. You have to work full-time, which is defined as 30 hours a week. And so you have to work full-time in one of these jobs that we talked about. And you also have to be making things that are considered eligible payments. There is also a new sort of concept of like something that's equivalent to a payment. But in general, in order for a month to count towards public service loan forgiveness, you have to have a payment due under a certain kind of repayment plan, and you have to make the payment that's due under that kind of repayment plan. There is some more nuance to it, but that is the gist of it. And it takes 10 full years or longer to meet the requirements to earn cancellation. So if you work in public service, enroll in the right kind of repayment plan, which we're going to talk about is mainly things called income-driven repayment plans, and then you make all the payments that are required from you each month while you're working in public service within as short a period of time as 10 years, or specifically 120 months, you could achieve cancellation of whatever balance remains. You can't do it in any shorter period of time than 10 years. And so that is kind of the gist of public service loan forgiveness. And it is, fortunately or unfortunately, kind of both, depending on how you're looking at it, is intimately connected to income-driven repayment. Now, when I say the phrase income-driven repayment, I'm referring to a category of repayment plans that the federal government offers for these federal student loans. There are several different plans that are under that umbrella term. There isn't a specific plan called IDR or income-driven repayment. That's just a category. So that's the header, and then the plans that exist underneath it. That what they all have in common is that they calculate the monthly payments a person has to pay with reference to their income and their family size, rather than with reference to their loan balance and interest rate and some kind of a specific length of time. Standard kinds of debt repayment is amortized or spread out over a specific period of time. And that's like if you have like a mortgage at for 30 years at a certain interest rate, they tell you the amount you have to pay every month for 30 years in order for you to pay the full principal balance as well as all the interest that will accrue over that period of time. And an amortization schedule is distributed over the period of time. Income-driven repayment plans are wildly different in that they are setting payment amounts without regard to the balance, but instead with reference to income. And there's a lot of detail we can talk about how income is determined or documented. But the important sort of broad strokes are that it is typically your adjusted gross income as reflected on your previous year's tax return, typically, although there are some other ways that it can work and does work in some cases. And if you are a married person, you have to file a federal tax return with the married filing separately tax status if you want your payments to be based on your separate income. Otherwise, they'll be based on your joint income together with your spouse. Although if they're based on your joint income, they will also take into account your spouse's student loan debt, if any. So there's a lot of potential, for borrowers to think through what's best for yourselves in that regard. And public service loan forgiveness only works and is only as strong as the income-driven repayment plans, generally speaking, the ones specifically that you may choose or be enrolled in. Because if you pay your loans on a standard schedule of 10 years, you would repay your whole balance over the period of time it took you to earn forgiveness. So the more affordable an income-driven repayment plan is, the more beneficial public service loan forgiveness has the potential to be for you or for the employers that rely on this program to help with recruiting and retaining experienced public service workers. So Payments that can be eligible for public service loan forgiveness are ones that you would make while enrolled in an income-driven repayment plan, having a payment amount due and making that payment amount. The income-driven repayment plans that exist currently are the Saving on a Valuable Education Plan, or SAVE, sort of, but stand by for the next few minutes while we're going to talk about the fact that SAVE isn't going to last and is already basically dead. There's another income-driven repayment plan called income-based repayment. There's pay-as-you-earn. There's income contingent repayment. Then in addition to these income-driven plans, technically payments made under a standard 10-year term of repayment, 10-year term only, can count towards PSLF. And when I say count towards PSLF, I mean allow you to get credit for one of the 120 months of credit you require in order to get the loan cancellation. So you get your cancellation only if you have 120 qualifying payments. And so that's your goal, right? If you want to get public service loan forgiveness, what you want is a record at the Department of Education and your loan servicer, but at the Department of Education that shows that they acknowledge that you've made 120 qualifying payments. There are, under the regulations, the ones that I told you are in effect now, but that could be amended at some point in the future. There are a few specific deferments that can count towards PSLF. Deferments are similar to forbearances in that they are periods where no payments are required. And typically when no payments are required, you can't get credit towards forgiveness. But there are a few specific deferments that now allow progress towards PSLF. So that's worth knowing. Also, though, very important, is that there are repayment plans that you could be enrolled in or could be considering enrolling in that do not, under any circumstances, allow you to progress towards PSLF or get credit towards qualifying payments towards the 120. And that's going to be the so-called standard repayment term for a consolidation loan. Because a standard repayment plan for a consolidation loan can be a length of time longer than 10 years, and it's based on the balance of the loan. So many people with graduate and professional degrees, for example, will have 30-year repayment terms that are referred to as standard for consolidation loans. And payments under those plans don't count towards PSLF. Similarly, payments under something called a graduated or extended repayment plan can't count towards PSLF. Those plans are still on the books, available, of little use to most people in most cases these days, but they are still, kind of out there to create confusion. All right, so deeper dive into income-driven repayment, and this is important because we have to address the litigation around the SAVE repayment plan. And I know many of you are caught up in that and want to know what you should do. So that you can decide what is best for you, I want to give you this information so that you can evaluate your current circumstances and decide whether you want to take actions or what those actions might be. Because not everyone's situation is different, but there are good choices for people in various circumstances, and they're not always the same. Okay, so important to know, the Higher Education Act, which is a statute, passed by Congress, created one income-driven repayment plan called income-based repayment, or IBR. And IBR has two versions depending on when you started borrowing your federal student loans. The one for people who had borrowed before the year 2014 is more expensive than the one for newer borrowers after July 1st, 2014. But IBR is a statutory construct, and that's important because that's relevant to this litigation that is ongoing that we need to unpack. The Higher Education Act also created a repayment plan called Income Contingent Repayment, or ICR, which has been on the books since the mid-90s. And ICR works a little differently in that it creates an authorization for the Department of Education, referred to as the secretary here, as the secretary of the Department of Education, to create a repayment plan within certain confines. And under that statutory authorization, for the last 30 years, various departments of education under various presidents have promulgated regulations that created these additional income driven repayment options that are authorized under this ICR section of the Higher Education Act. The ones that they created are pay as you earn, revised pay as you earn, and then this plan called SAVE. And SAVE was the newest plan that was created by this negotiated rulemaking process under the Biden administration. It offered the lowest payments and the quickest progress towards forgiveness, and some important limitations on the way interest accrues or doesn't accrue when you're in the repayment plan. And I should mention, when I say faster forgiveness, I'm referring to a sort of secondary kind of forgiveness that is not public service loan forgiveness. There's public service loan forgiveness that allows folks to get loan cancellation in as little as 10 years or 120 months of employment in certain kinds of employment. So that's PSLF. And in order to get PSLF, you have to enroll in one of these IDR plans. But there's also forgiveness that is not tied to your employment at all. And that is sometimes referred to by various names, but it's this sort of long-term IDR cancellation or forgiveness. And forever, it was uncontroversial that under the authority in the income contingent repayment plan, that the Department of Education could cancel debt when it wasn't, if it wasn't fully repaid after 20 to 25 years, depending on the plan. That has now been called into some question with this current litigation, and we'll talk about that some more. But the SAVE plan had sort of accelerated forgiveness provisions that had not previously been as quick under these other plans, and that is part of what they're arguing about in the context of the litigation. And all of these plans are income-driven repayment plans. So income-based repayment, income contingent repayment, pay as you earn, revised pay as you earn, which doesn't even really exist anymore because it was amended to turn it into the SAVE plan. SAVE and repay are the same plan for now under existing regulations. Okay, and the reason all this detail matters is so that we can understand the impact of this current litigation. So what happened is the SAVE regulations were promulgated. They were it was one of the marquee policy provisions of the Biden administration. So it was hated by some attorneys general and 7, in fact. And so they filed a lawsuit in April of this year. This has been led by the Attorney General in the state of Missouri. Missouri is where the well-hated organization, MOHELA, which is Missouri Higher Education Loan Authority. That's a student loan servicing company. That's where MOHELA is based. And MOHELA has been determined to be sort of quasi-governmental, and that's how the state of Missouri had standing in a lot of the litigation that has impacted the Biden administration's policies, including their loan forgiveness efforts for some more kind of across the board forgiveness. You probably recall the U.S. Supreme Court decided that the efforts to do broad-based student loan cancellation were deemed impermissible, and it was MOHELA's existence and involvement that provided the hook for them to be found to have standing. So in April, they filed a lawsuit seeking to enjoin application of the SAVE plan. In August, the Eighth Circuit Court of Appeals granted a broad nationwide injunction on the implementation of the SAVE repayment plan. Not after, or not before, I should say, some 8 million borrowers had been enrolled in the plan. That created, immediate chaos. Just recently in October, end of October of 2024, There were oral arguments before a panel of the Eighth Circuit, and the panel is clearly inclined to strike down the SAVE plan, which may not even matter that much because no one expects the incoming Trump administration to defend the SAVE plan in court any further. One of the alarming things about these sort of current events is that the way that the litigation has been framed by the litigants and importantly by the court is that it could have some broad implications for the whole income-driven repayment scheme, because the court is seeming to question whether there is authority to promulgate regulations to create these plans at all, or to forgive debt at all after 25 years. So again, PSLF, cancellation of balances under PSLF, not the same as cancellation of balances under these income-driven plans. But the existence of these income-driven plans is, major with regard to PSLF. So, it could be that the Eighth Circuit rules any day now. And it's also the case that when the new administration takes power, they may well not, participate in litigation. They certainly won't participate in the same way that the Biden administration was. So that will impact how long the litigation is pending potentially and what the ultimate result is. But right now, all we really have is an injunction. So we haven't had, the case hasn't been decided on the merits. But what it has done is cause all kinds of chaos within the whole student loan, world. At the beginning, immediately following the injunction, the Department of Education was forced to take all the income-driven repayment applications down altogether so that people couldn't even apply to enroll in these plans. They then reinstated the availability of the applications initially on paper. Now there are electronic applications available, but they are still immersed in something they're calling a processing pause that is across the system. And this is because, they literally don't they can't just turn on a dime, right? The student loan system and the servicers and their, kind of computer systems, you can't just change the way that these applications are processed easily or quickly, especially if you don't have money to make changes. So the servicers have had to make updates to their systems. And so we have been told right up until, now that processing of the pending applications should resume any day now, should resume soon. And, for all I know, it may be happening even as we speak. Although I've not, we're certainly not seeing hordes of borrowers having, their applications approved. And there is a tremendous backlog. So it is unclear how long it will take for them to get through all the applications, even when they do start processing them in earnest. And so as a result of all of this stuff and the fact that they really couldn't implement SAVE and couldn't really calculate payments under other plans either, the Department of Education decided they had no choice but to put people's loans into something they're calling a general forbearance. And, so the good thing about the SAVE forbearance that is being referred to as a general forbearance is that it is zero interest accrual. So it has stopped the increasing of balances for people who are in that forbearance. But the department has taken the position, took the position from the beginning that the forbearance would not count towards public service loan forgiveness. Even if you're making payments, has been the position that they have taken. Now, I assure you that people like me, and not just people like me, but me, have done, have tried our hardest to, and have from the beginning to argue that was not required, necessary, prudent, that it shouldn't do it, that they should change it, and all of this. But there are those who had determined that it was, that they didn't have the authority. And, you know, so that's what the guidance is. And when it comes to like, well, what if I just want to keep making payments? If you're in the forbearance, we've had no indication that you actually paying money helps you get credit for those months towards PSLF because of what I referred to earlier, which is that they have taken the position, again, for years, they've taken the position that you can't make a payment that counts towards PSLF unless a payment is due. So if you're in a forbearance and $0 is due, it don't matter what you pay, they say. And so now maybe could we get this to change at some point in the future? Yeah, possibly. It's certainly not, I have no reason at all to expect that we could do that during a Trump administration. So if you are someone who is just getting started towards PSLF, will I tell you it's impossible that we could at some point scrape credit together for these months retroactively? Yeah, maybe we could. But also maybe we couldn't. So, and if you're closer to PSLF, that's no comfort to you. Now, so how long will this forbearance last? Okay, nobody knows, but the current administration has announced that it will last through at least April 2025. There is some likelihood that it could last potentially much longer, because even if a new administration wanted to immediately lift the forbearance, it's not clear that the servicers would be able to implement that quickly. Now, because they have to have, they have to do something else with the people who are enrolled in the plan, right? So they either have to process these IDR applications, or they have to, Lord knows what's going to happen. So let me just say, like, people like me, we talk about this all day, every day, and people are monitoring this and doing what we can to make it go as smoothly as we can for people like you, but it's a mess. And the system doesn't work well, on a good day. So it's definitely not working well under these circumstances. But so of course I know that, like, what you need to know is what should you do for yourself to protect yourself. Okay, well, first figure out if you're in the SAVE forbearance or not, right? You may or may not be. Be sure you check. And let me pause to mention, like, your favorite website, well, not your favorite, but the place to deal with your student loans first and foremost is studentaid.gov. Do not only use your servicer's web interface. You will also want to go to your servicer's web interface, and you'll have to, but you should go to both places. And you should make sure that your profile settings and your notifications and your contact information are up to date on both those places. And when it comes to PSLF, you should look at studentaid.gov and see whether you are enrolled in the SAVE forbearance. You can also find that information on your servicer site, or if maybe you're enrolled in a different repayment plan. And if you're a brand new graduate, recent graduate, your loans are probably just coming out of the grace period, which is that 6-month period after you leave school. If that's the case, you're going to have to figure out how to get enrolled in a repayment plan that you can afford. And so should you enroll in or switch to another repayment plan? Well, it depends, right? So you could quickly get into the standard 10-year repayment term. That's the only thing you can get the system to do relatively fast. You can't just call up Mohila and say, I want to waive the forbearance. The only way to quickly get out of the SAVE forbearance is to let them put you in a standard 10-year repayment term, which is probably going to be expensive. I mean, and certainly if you have a high balance, it will be expensive. But it has the potential to count towards PSLF under existing rules and to get you out of the forbearance. That's the fastest thing you could do. It is possible that you might be well served by filing an application to switch from the SAVE plan and its forbearance into the plan called income-based repayment, IBR, because IBR is statutory. So it will survive the litigation. It cannot be eliminated through this litigation. But the questions we have are, well, when will that application even be processed if you file it? We don't know how long that might take, and it's very likely that it would be a matter of months, certainly not days or weeks. It will have higher payments potentially than you were used to paying under the SAVE plan. I mean, it certainly will, than you were paying under the SAVE plan before the injunction. Some people may not even be eligible to choose income-based repayment. It has a requirement of demonstrating something called a partial financial hardship. Essentially, what a partial financial hardship means is that you have to show that your payment under IBR would be less than your payment under a standard 10-year repayment term. So for some people, especially those who have higher incomes, vis-a-vis their balances or higher income to debt ratios, not everyone will qualify for IBR. There are some other downsides to IBR, like if you enroll in it and then you later switch, that will trigger capitalization of interest or adding of interest to the principal. That can be expensive over time. And there's another option that we're going to discuss called PSLF buyback that might be cheaper than switching into IBR if it lasts. The other complicating factor is that the Department of Education has recently dropped new regs to allow them to reopen applications for the plan called Pay As You Earn. So potentially you also have to weigh whether you would want to enroll in Pay As You Earn. Pay As You Earn has some potential to be messed up by the current litigation, however, because it is one of the plans that was created by regulation of the department, although it's been in effect a lot longer, so it may survive. There are some, it's very complicated in terms of what you personally would be better off doing between IBR, Pay As You Earn, standard 10-year repayment. So these are the things you should be considering. Let me show you a couple of numbers real quick before we move on to some other things about what we can expect from Washington, and then some Q&A. And these slides have been made available to you through the Dropbox link. So if you want to take a closer look at any of this stuff, this is just kind of showing you a couple of examples of different adjusted gross income figures. I only have on this slide 100,000 and 200,000, and it's according to your family size. So this kind of just shows you what those amounts would be. And the SAVE amounts are really just for illustrative purposes because, I do not expect anyone to get to stay in SAVE long term. I should say, however, that weirdly, you can apply to enroll in the SAVE repayment plan still right now. And if and when that application gets processed, you get put into the SAVE forbearance. So to the extent that some folks might be better off just getting the interest to stop accruing and having no payments due, that remains an option at least for the time being. Okay, so getting back to how all this affects public service loan forgiveness. I mentioned that it's all about counting so-called qualifying payments, right? You want to bank qualifying payments. And what that means is that a qualifying payment is something that is recorded at the Department of Education as you got credit for that month towards the 120. So that is what you want. You want qualifying payments, and you only get qualifying payments after you certify your employment by filing something called the PSLF form. So to get a qualifying payment, you have to be enrolled in an eligible repayment plan, like an IDR plan, have a payment due, make the payment due, and also prove that you were working in a public service job when you did all that stuff. And until all those things come together, you don't have any qualifying payments. So eligible payments are when you make payments under an income-driven plan that would qualify towards PSLF when you prove that you were working in a public service job when you made them. So this is what we want for ourselves and our friends and loved ones. We want qualifying payments. And so everyone, no matter what is going on with forbearance, income-driven repayment, anything else, you should file these things called PSLF forms, and you should do it one way and one way only. You should do it electronically via studentaid.gov. Do not print a PDF and sign it and upload it. Do not print a PDF and sign it and fax it. Use this electronic tool because this is the only way that you get a timestamp and an official record with the federal government that you have filed this form. And that is why I urge you to use the PSLF help tool. You can do this as often as once annually, and you can do it for all your jobs. All you need in order to get it done is the federal employer ID number of your job, which you can get from your W-2. And then you can add your employers using their little button to add them. Then if you have the email address of like your HR person or someone at the organization who can sign to show that you worked there, they can get a request to sign the form digitally. And this is what you want. Then they'll get this request, they can review the document, pop their signature in, and that will enable you then on your studentaid.gov interface to see where that the form is filed and what is the status of the form. So if you're in this system, you should be checking this stuff for yourself. It will show whether your employer has signed it, whether it's pending or what, and you want to check that for sure. Also, there is now a place for you to see your progress towards PSLF. You can see the whole payment history, the employment certifications, and more of the detail. So you want to log into studentaid.gov and then navigate to the My Aid menu, and then you can look at these PSLF payments. What I usually do is I first look at the employment certification tab to make sure they've received the forms for all the dates that folks have been employed, and then look at the payment history. And what you want are those green circles that say qualifying. What you'll see now, if you're in the save forbearance, are red circles that say ineligible, meaning that even when you certify your employment, they won't give you credit for these months because no payments are due currently. And so that's important. You may well also see months in which they say eligible, and eligible means you have to certify your employment to get it to toggle from eligible to qualifying. And qualifying is what you want. You also want to make sure that you are getting the notification when they have processed your PSLF form, because you now have a 90-day time limit to request reconsideration if the review of your form is faulty, which it often, well, regularly, I should say, is. And so you don't want to run out of time to request that reconsideration. More information about how you would request reconsideration is at studentaid.gov. And now we arrive at the PSLF buyback moment when I say that PSLF buyback is a new thing. It's in these regs that took effect July 1st, 2023. And it's what we're being told is how you're going to recapture credit for these months in the save forbearance. And that is something we will fight to keep in the regs, but it is regulatory in nature. So it is not for me to say whether it will for sure exist when you might need it. Also, the procedure for actually doing it is definitely going to be bumpy, and maybe potentially really bumpy. But it involves sending an email to the Department of Education requesting reconsideration after you have completed the whole 120 months or 10 plus years of employment, because it's only available once you are applying and saying, hey, I'm ready to get my loans canceled because I've done my 10 years of public service. And then they say, no, actually, you had those months during the save forbearance that didn't count towards the 120 months. And then you say, yeah, but let me give you the money now that I would have given you then, but you told me I couldn't. And then you wait for them to tell you how much that is. So what you should do is make sure you keep a record of what your payment was right before the save forbearance hit. So in June of 2024, what were you paying on your student loans? Go to your loan servicer's website, download your loan history, and keep that in the cloud so that you have it if and when you want to pull it out in 5 years or 10 years from now. Also, keep your own income documentation so that you can document what your payment woulda, coulda, shoulda been if you had been enrolled in a qualifying plan. Okay, so I am going to tell you my thoughts for what might happen in the new year with the new crew in Washington. And while I do that, I would like to invite you to put whatever questions you have for me into the Q&A. And then following this, I will look at those and take some of those. Biggest thing I'm worried about right now is a budget reconciliation process that is surely going to be launched almost immediately in the new year by Congress. The reason I feel like this is a potential threat to student loan borrowers and public service loan forgiveness is that it requires only a simple majority in the Senate in order to get it done. So it is I think unlikely that there are 60 votes in the Senate, which is what is required to overcome a filibuster to do anything like eliminate public service loan forgiveness. And I should say, none of the proposals would even impact people who are already working towards PSLF or who have already borrowed student loans even. So when I say I worry about potential for PSLF to be eliminated by Congress, I do worry about that, and we will be working on making sure that that doesn't happen. But I think that the biggest threat would be to future generations of borrowers. So generally, the way things happen is it would be dependent on when you borrowed your loans. So if you, presumably attending this session today, already have student loans, you should be okay even if this particular doomsday scenario comes to pass. But of course, I don't have a crystal ball. I don't know for sure. I'm just basing this on, the years of experience and what has so far been proposed, even by, the folks who are going to be in power. But budget reconciliation is going to be a time when they are looking to cut funds from every government program, including the Department of Education, including PSLF, including the income-driven repayment plans. And it can happen very quickly, and it can happen with a simple majority. So it will be starting in January, but it will probably be a sort of two-phase, process. My guess is that by around May and certainly by August, if something really significant doesn't come out of reconciliation, that then, I'll breathe a little more easily in terms of congressional action that could severely limit PSLF for future generations. So I encourage you to stay, engaged and informed about the issues. I'm often asked these days, will they eliminate the Department of Education? This has long been a talking point. Ronald Reagan started talking about this. I think it's pretty unlikely that it would actually happen. Congress would have to pass a law to do it. I think it's unlikely to be, entirely eliminated. I do think that it's likely to be, there will be less funding, fewer employees. And there are plans for how it could be, the Department of Education could be effectively mostly dismantled. But the main thing that I hear from the folks who are going to be taking power with regard to this is they're mostly saying things more like, they want to get these big block grants and just give the money to the states rather than have the federal Department of Education do as much, stuff. So, most of the talk about this isn't related to higher education at all, and certainly not related to the student loan system, because as you are likely aware, they also want to collect on student loans, and that is currently done by a aspect of the Department of Education called federal student aid. So federal student aid either isn't going anywhere or their functions would be assigned to another agency potentially, because there's no, in some ways, man, it sounds kind of great from a student loan perspective. Okay, eliminate the Department of Education, then how nobody's going to pay there'll be no way to pay student loans. You didn't have that. But of course, that's not, exactly true. Linda McMahon has been proposed to be nominated to be the Secretary of the Department of Education. So what do we think that a Secretary McMahon might do? We know that she comes from a business background, and so has, is likely to, her time at World Wrestling Entertainment shows that, they were very it was a very savvy business in terms of cost cutting and profit, increasing. So I think that business experience is something we would expect to see her bring to the Department of Education. And, she doesn't have a lot of direct experience in the field of education, but she did chair an entity called America First Policy Institute that has some, similar kind of talking points that I'll show you to like Project 2025, for example. I think it's also important to acknowledge Linda McMahon has been and is personally connected to Trump, and so I think that is worth knowing. I think I think she would surely be working to effectuate the policies of the president. Well, so what did America First say about higher education? That it should be reformed in various ways that mean that, that are very certainly anti student loan forgiveness and cancellation. And I did include some additional kind of information about what has been said in the past about what the federal policy might look like. We don't need to go over those together, but if you're interested in looking at them further, you certainly can do that. And now let me look at your questions. Definition of full-time. Can I repeat it? Absolutely. It is 30 hours a week. Not 40 hours a week. It is 30 hours a week. There used to be a more elaborate definition of what full-time was. But the current definition is 30 hours a week, and that is retroactive for the entire length of PSLF. So that is the only rule now. Okay. So I'm asked if I can recommend someone who works directly with borrowers. So that's right. So I don't make myself available for hire directly by borrowers. I do work with employers. So to the extent that you want your employer to support you and your student loans, which I think is important, right? So you're working for a place that is benefiting from your education. So I can be engaged to do individual counseling through employers and professional organizations, but not directly by borrowers, because I don't want to charge you money. I mean, that's the gist of it. I never have, and I don't intend to start now. But I do train some financial advisors. There's something called a Certified Student Loan Professional, CSLP, Certified Student Loan Professional. These are people who have licenses as financial advisors and who have taken a rigorous course of study that I'm one of the lead instructors in and passed a very difficult test. So I think those folks are a good place to start. I will say, however, they also have a lot of uncertainty right now, just like me and everybody else. Okay. Are there resources for, oh my God, the questions are coming in fast and furious. So Wendy asks, if we apply for other IDR plans now, will we remain in the save forbearance until the IDR plan application is processed? Yes, if you are currently in the save forbearance, you will remain in it until you are enrolled in a new repayment plan, which would mean if you file an IDR application, it would have to be processed and you would eventually get notification that you're enrolled in a new plan. Now, of course, it's also possible that something goes different with the save forbearance before your IDR application was processed. So someone's wondering what they can do to speed up or follow up on a submitted buyback request recently. I think that's an excellent question. I'm glad that you have submitted the request. I wonder how long ago you filed it. I imagine it couldn't have been too long ago. I think that it is really important that we all file the buyback requests that we have when you're eligible to file one, and that you continue to follow up by, I think, sending email to that same place where you sent the buyback request. Also, potentially after a certain period of time has elapsed, maybe 30, 60, 90 days, or at those intervals and going forward, you can submit a complaint via the studentaid.gov website, which will get you into the ombuds group, which is an attorney at the Department of Ed that might be able to help some. But here's where we're also going to have problems potentially with the new administration. We've had problems all along, obviously, with these procedures. And in the new administration, I fear that we could be, putting our applications and our requests to buy back into some kind of a void where we don't hear back. So the other thing that you can potentially do, and that we may have to take some of these actions, contact the Consumer Financial Protection Bureau, your elected members of the U.S. Congress at both the House and Senate side. Do these things in writing, like on paper, like the kind that you have to cut down trees to get, and mail them. And because it's possible that if you can get your elected congressional representatives interested, that they can follow up with the Department of Ed on your behalf, and that is probably the most likely to actually shake down any response. I'm asked for clarification on which plans might allow folks to make qualifying payments. So you can make qualifying payments towards PSLF under a standard 10-year repayment term. So what you could do, and you may want to do, is request that your servicer clarify and confirm what that amount would be under a standard 10-year plan, because that can be very difficult to calculate on your own, because it's hard to know what balance to use and what length of time, because it's not 10 years from today, right? It's 10 years in your maximum repayment term. But see if you can afford it, because if you can, and you're towards the end of PSLF, that is going to be the fastest way, not the cheapest necessarily, but the fastest way to start making payments that should be counted in real time. And so standard 10-year payments and IDR payments is basically it. So someone is saying they're not in SAVE, but in IDR. Again, nobody's in IDR. IDR is not a plan. So if you're in IBR, that's great. But if so it may be that you filed an application to enroll in something and it hasn't been processed yet. So you should check on studentaid.gov and see if you have any under my documents and my activity, and see if there's pending IDR applications. And if not, you may need to refile it if it was literally lost, which does happen. So Ruby's asking if, while in the forbearance, can apply for PSLF, or whether Ruby has to wait. So there's two things that the PSLF form does. it certifies your employment and it applies for actual forgiveness, but it doesn't apply for forgiveness until you've done 120 months or 10 years of employment. So if you're in the forbearance and waiting to get enrolled in an income-driven plan, you could file a PSLF form now saying, hey, look at me, I work for Legal Aid of California. But if you have never been enrolled in an IDR plan or made payments under that plan, the response to the filing of that form would be, so what? You still don't get credit for these months because you were never in the repayment plan. So most of the time I tell people that they should wait until they have a few months at least in an IDR plan and making payments under that plan before they bother filing a PSLF form. I'm starting to feel inclined to say, like, what's the harm in filing one that we know will be denied? Because at least then you've kind of like got something tagged on your record that you've done it. Just because, God forbid, worst case scenario stuff starts happening in Congress and they start drawing lines about like who's got their foot in the door and who doesn't. Can I imagine a world in which having filed that form already is protective? I can. So you can file it, but you won't get any, very useful response to it. I'm asked whether there's any instance where they should not use the PSLF form, even if they've had some late payments. No, you should always use the electronic version of the PSLF form. You should always, no matter what. If you have a signed printed PDF, if that's all you can get, then you should upload it. But if you can get your previous employer to instead do an electronic signature on an electronic PSLF form, you should do that. Because it's mo better. So then I'm asked about whether the deferments during COVID will count. Yes. So COVID and if you have not already certified your public service during the COVID payment suspension, for God's sake, please file that PSLF form now so that you can get credit for those months. Like if you're someone who's been working in public service and you haven't filed that form, please do it today. Please do it today. Because whether you can or should get credit for past payments is wholly determined based on the filing of that form. And I'm worried that they won't be processing those forms as fast or in the same way. I hate to say, but it is true that like one way that PSLF could be, harmed, and you could be harmed by a new Department of Education is they can just slow roll the processing of the forms. And we may have to try to push to get them to even process them. And if they do process, we saw this in the first Trump administration with something called borrower defense, where student loan borrowers had proved that they were defrauded by their schools. And so they were supposed to get their balances kits. And the Trump administration sat on those applications for the entire 4 years that they were in office. And so these are the sorts of things that that we can expect to happen in the next term. And so I want to encourage you to, steel your spines, take a deep breath, and prepare for advocating for yourself and, potentially waiting some things out. Right? So do what you can to protect yourself. What can you do to protect yourself? File the PSLF form. Figure out whether you're in the SAVE forbearance or not. If you are, decide whether you should file an application to switch into a different income-driven repayment plan. My, slight preference is for IBR, income-based repayment, if you can afford it, because it's statutory. And also, watch this space and the media to see when something happens with the SAVE litigation. Because fairly soon, either the Eighth Circuit will rule or there will be some potentially even like settlement agreement between the new administration and the litigants that says, okay, we're abandoning the SAVE plan. And then what will happen with IDR, there's a lot of potential outcomes that we don't know today as we sit here in December of 2024. So I know that we are at time. We are 5 minutes over, and I know that you guys are very busy and have other important things to do. That said, I have enough time to stay for another 10 minutes if people want to stay. I will answer additional questions. I don't want you to feel like you have to stay. Someone has extremely high payments under an income-based, they think, repayment plan. Consolidation shouldn't be affecting your payment amount at all. If you're in an income-driven plan at all, including the income-based plan, whether your loans are consolidated or not, has nothing to do with what your payments are. What has to do with it is your income and your family size. So if your payments are extremely high, it's either because your income is extremely high and or that you're married to someone with income and you're filing a joint return and they're using your joint income. It is also possible, and I want to acknowledge that, like, even if it's your separate income, and even if it's not sufficient for your income is not sufficient for all of your expenses, I don't mean to say that income-based repayment is always affordable. It's not. That's why we needed the SAVE plan, but we won't have it. But it's all you got. It's the best you got. So those are the things you should check, though. If your payments are extremely high, figure out what income figure they're using, and because that's the main driver. Elena wants me to confirm that pay as you earn is not statutory. That is correct. It is not, and is therefore less certain to withstand the attacks. Yes, correct, exactly. Pay as you earn is potentially also at risk by this litigation. Income-based repayment, IBR, B as in based or boy, is the only income-driven repayment plan, with the exception of the one called income contingent repayment, which is super expensive, that is statutory. And I should say one more thing to the person who said that their income-based payments were extremely high. It's also possible in the case of that person that you're enrolled in income contingent repayment, or ICR. And the most people who are enrolled in ICR are there because they have to be, because they have parent loans, or they have a consolidation that included parent loans. And that plan is really expensive for a lot of people. But it's also the only option if you have those parent plus loans, or a consolidation loan that repaid parent plus loans. So that might also be why your loans are super expensive, potentially. Ryan's asking about if you first borrowed before the 2014 IBR rate cutoff, but then consolidated, whether that changes the impact of the 10 versus 15% of discretionary income. No, it's the date upon which you got your first loan. It is not related to when you got the consolidation loan. So that doesn't it doesn't help you. You're still stuck with the original IBR. Anonymous asks, if I get married, will I have to file taxes as married, filing separately so that my spouse's income isn't considered for payments? So you choose whether to file your taxes married jointly or married separately. You get to / have to, as a married person, choose that each year. But you and the only way to pay based on your separate income is to file separately. So yes, if you want your spouse's income to be excluded, you have to file a separate tax return. But you don't have to file a separate tax return. You can file a joint tax return and have your payments based on your joint income. And like, if your spouse is a student and not making any money, that's probably what you would want to do, right? So that's it. Judith is asking, what is a parent-based loan? There's something called a parent plus loan that is for parents of undergraduate dependent students. And that's a certain kind of federal loan that's eligible for forgiveness, but that is limited in the IDR plans that can be chosen. I didn't mean to, if I did say that pay is in forbearance, I didn't mean to say that. Pay is not in forbearance. If you were enrolled in pay, you can still be making payments towards PSLF under pay. But what happened to pay is that because of the litigation, well, not just because of the litigation, new applications for pay were eliminated by the regulations that are being challenged in litigation. So pay for new enrollees was shut down. Then there was the litigation, but there was no forbearance if you were already enrolled in pay. Now the department is reopening pay for new applicants. But no, if you're in pay as you earn or income-based repayment, you're not in the SAVE forbearance. And so you can continue making those payments towards forgiveness. Oh, great. So the PSLF tool is unavailable at this time. Great. So the student aid site does go down periodically, especially when they're updating things. So I would say try again and refresh it and try again. So Ashley wants to know if they do away with SAVE, what plan will we be put into? IBR? Okay, so nobody knows, Ashley. That's the thing. We don't know. It depends on how the SAVE stuff is resolved. And it also depends on like what's possible for them logistically to implement. But no, I think it is very unlikely that you would just be put into IBR. I think what is more likely is that you'd get a bill for the standard 10-year payment amount, which is going to be high and shocking to a lot of people. And then you could and would want to immediately, if you hadn't already, file an application to enroll in IBR or another plan. And because you have to provide your income documentation and all that. I think I can't even imagine how they would just like switch people from the SAVE forbearance into IBR automatically. They're almost certainly going to sort of punt it back to us in a way that will be, unsatisfying. Oh, cool. So Elena is confirming that pay is back up. So that's great. And that they're processing those applications. We had been told that that would start as of December 6th. I was a little bit, I hadn't had that yet confirmed. So that's great to know. Sophia's getting notifications from Mohila that interest is accruing during the forbearance, and she wants to know how to fight that as part of the SAVE program. So there's forbearances and there's forbearances, and there's form letters. So generally in a forbearance, interest does accrue. And the servicers, including Mohila, use all kinds of like pre-packaged, letters and language. So it might, Sophia, just be that you're reading language from Mohila that isn't literally applicable to what is in fact going on during the SAVE forbearance. It's also possible that you're in, that they have messed something up and have you in some other forbearance. But the so-called general forbearance, according to the SAVE litigation, is supposed to be zero interest. So I would look more closely at your accounts, not at the notices, but look at your payment history, look at your balances, look to see whether they are in fact charging you interest. And whether you are in fact in the SAVE forbearance. And those would be the questions that I would be asking and trying to get to the bottom of in your case. Okay. So yeah, so I'm getting other messages from folks about like confusing information from their loan servicers. Antonio's talking about having gotten emails that payments had been missed and seeing zero balance due. So I certainly don't recommend panicking when it comes to the student loan stuff. So, what you want to do, Antonio, is, log in at your loan servicer's site at Ed Financial and also at studentaid.gov and look for something called loan status to see if your loans are in a forbearance, which is a status. Whether you actually have a payment due is, if you're not in a forbearance, the amount that is due depends on what plan you're in, when you last paid, how they attributed that payment to your loans. So you're certainly going to have to seek more information from them, and you definitely want to try to get to the bottom of that. What you don't want to do is, like, if you just get a bill that says like, hey, you have to pay this bill now, like, and understand, it's understandable that you'd be like, oh my God, I need to pay this. But like, no, first you will need to like understand it. And also recognize that, like, you know, when you get a bill and if it's not right, like paying it, you're gonna give up some opportunities to like not pay it, right? And the first thing that happens if you are supposed to pay and you don't, it takes 30 days before any creditor is going to do anything about that at all that would have any negative impact on you, like reporting it to a credit agency. So you have a whole month to be like, okay, what is going on with this bill? Why did you bill me this? Should I really pay this? I shouldn't have anything due. So those are the questions that you want to figure out. And I hear often from borrowers, especially folks who are relatively new to like owing money or dealing with stuff, like it is scary and awful, and they send you scary letters, but you really want to try to like advocate for yourself and educate yourself, and it will require you to take some amount of time in order to do that. You certainly don't want to just trust the debt collectors. That's for sure. All right, y'all. Well, I will not keep you any longer. I know we could kind of all go, I could go on like this forever, and I imagine that there's some appetite for that for y'all as well. But I know that the good folks who convened this meeting will do so again in the near future. And I really appreciate the public service that many of you are doing, and I feel your pain, and I promise you I will continue to advocate for you and your interests every single day. So, yay. All right, guys, take care.